principal threads sewn into the fabric of legal systems. In determining whether or not the United Kingdom Supreme Court's decision in Patel against Mirza has resulted in significant change, we will analyze the formula approach adopted prior to Patel against Mirza, as well as the new approach that was introduced in Patel against Mirza, comparing and contrasting the two. Along the way, we will consider the merits and faults of both approaches and conclude whether or not the law has been settled and clarified in this area by determining if there is a sole approach that will be utilized by the courts when confronted with the defense of illegality.
For the principles of illegality in Malaysia and UK, prior to the ruling in Patel and Mirza, there were 3 exceptions to the second general rule of illegality, whereby the recovery by the claimant will be allowed, namely the in pari delicto rule, the no reliance rule, and the locus penitentiae rule. Firstly, when the claimant is not in pari delicto or not equally at fault, courts will allow recovery. In simple terms, a party is not in pari delicto if he is not aware of the illegality when the agreement is made. This was demonstrated in the case of Hughes and Liverpool Victoria Friendly Society, where insurance premiums were paid by the plaintiff for insurance policies which he did not have any insurable interest. Applying the first exception, he was able to recover the premiums paid because it was induced by fraudulent misrepresentation. This principle has been integrated into Malaysian law under Section 66 of the Contracts Act 1950. In the case of Eng Hong and Maneka, neither party was aware of the legality at the time of making the loan transaction. The illegality was only discovered after the proceedings began. Section 66 applied and the application to sell the charge of land was allowed. The second exception to the rule is that where the illegality is not relied upon to prove a right to the property sought to be recovered, the claim will succeed. The House of Lords in Teasley and Milligan applied the exception to allow the respondent's claim of half of the house because even though the intention for removing herself from the title was illegal, she did not rely on illegality to prove a claim. The same principles were applied in Malaysia in the case of Sergeant Singh and Saudara Ali. The contract between the parties was immoral, applying Section 24E and was thus unenforceable. The claimant did not rely on his claim for the contract but rather on his title. Therefore, his claim was allowed. The third exception is the locus penitentiae principle, which prescribes that when there is a timely withdrawal from the illegality before it was carried out, the claim for recovery will be allowed. The case of Tribe and Tribe is relevant here. The father transferred his company shares to his son to avoid his landlord from executing the share against him. Although this would have been illegal, the illegality did not materialize and hence the father can recover his shares from his son. This principle was adopted in Malaysia as well, in the case of Palaniapa Chetia and Arunasalam Chetia. The claimant had to rely on his own illegality to prove his title and the fraudulent purpose had been executed fully. Therefore, the principle could not be relied on successfully, and the claimant's claim to retransfer the property back to him was dismissed.
In 2016, significant changes were brought to the traditional rule-based approach in the landmark case of Patel against Mirza. In this case, Mr. Patel gave Mr. Mirza £620,000 to bet on the price of bank shares using insider information. Both of them were aware that such an agreement was illegal in the United Kingdom. However, the insider information never transpired and subsequently the insider dealing did not materialize. Mr. Patel sought to recover the money paid to Mr. Mirza, relying on the law of unjust enrichment. Initially, the High Court dismissed Mr. Patel's claim upon relying on the no-reliance principle because Mr. Patel had to rely on the illegality to establish his claim. On appeal, Despite agreeing with the application of no-reliance principle by the High Court, the Court of Appeal ruled that Mr. Patel was allowed to recover the money based on the locus poenitentiae exception, since the insider dealing did not happen at all. From these two decisions made in High Court and the Court of Appeal, we can observe that there are inconsistencies on how the judges apply the traditional rule-based approach. This problem was eventually detected by the Supreme Court judges. Although their lordships unanimously agreed that Mr. Patel should be allowed to recover the money, the majority led by Lord Towson had rejected the traditional rule-based approach and introduced a new one. Lord Towson's new approach revolves around the trio of consideration, whereby a judge should take into account, firstly, the underlying purpose of the prohibition which has been transgressed, secondly, the possibility of any other relevant public policies which may be rendered ineffective or less effective by denial of the claim, and lastly, the possibility of overkilling unless the law is applied with due sense of proportionality. In adopting the trio of considerations, His Lordship suggested a non-exhaustive list of a range of factors put forward by Professor Burrows, which should be taken into account. These factors may potentially include severity of the illegal conduct, centrality of the illegality within the contract, the consequences of allowing or denying the enforcement, and the maintenance of the integrity of legal system. Lord Towson's main reasoning in advocating for the new approach is to ensure principled and transparent judicial decision-making. His Lordship pointed out the underlying issue within the no-reliance principle laid down in Bowmakers and in Tinsley. The principle itself revolves around procedural issues as opposed to the merits of the case. Applying the principle, the court only took into considerations which path the claimant takes to establish his claim. Due to the ill-defined nature of the concept of reliance, it gave room for potentially unjust outcomes that were highly arbitrary. As long as the plaintiff who committed the illegal conduct can find alternative means to establish his claim without relying on the illegality, he would succeed. For that, His Lordship overruled the reliance principle and replaced it with the new approach which revolves around the idea of proportionality. His Lordship believes that it is essential for the court to consider the policy factors in applying the common law doctrine of illegality. In doing so, judges would be able to provide logical and clear reasoning for each of their decisions. Lord Towson also opined that punishment for the wrongdoer should be carried out by the criminal courts and not the civil courts. Therefore, a person who satisfied the ordinary requirements for a claim in unjust enrichment should not be debarred from recovering his money, even though it was paid for illegal purposes.
The minority judgment for Patel and Mirza was led by Lord Sampson and agreed by Lord Mans and Lord Clark. His Lordship rejected the policy approach, pointing out that it gives courts too much discretion, thus widening the scope of illegality. This would result in inconsistency and uncertainty in the law, as judges are allowed to take a wide range of factors into consideration, especially under the proportionality lens. Further inconsistencies would arise, as judges will have to decide the severity of the illegality when applying the rule. Moreover, the new test also disregards the requirement of a connection between the illegality and the recovery claim. One must be reminded that the illegality rule was designed to protect the public interests as a whole, not merely the legal interests of the parties. Lord Sampson's perspective on the novel approach had been supported by certain authors, some even openly favouring the rule-based approach advocated by His Lordship. A reasonable point which had been brought up suggests that the unclear and immutable definition of public policy, which is the root of this law, promotes further incoherence in the law of illegality. Judges should base their decisions on a structured framework to allow for certainty and consistency within the already confusing law of illegality. As Lord Thompson put it, the trio of consideration accidents all the vices of complexity, uncertainty, arbitrariness, and the lack of transparency, and adopting it would be substituting a new mess for the old one. With the new rule of illegality at such an early stage, it is predicted that judicial decisions will be inconsistent, leaving legal advisors and their clients as the primary victims of these uncertainties. Following the introduction of the trio of consideration, the question then is what happens to the other two principles that were not explicitly overruled in Patel and Mirza. In the majority judgment, Lord Thompson referred to Professor Burroughs in paragraph 82, commenting that the court finds it difficult to lay down clear rules pertaining to the impari delicto rule, but his lordship did not explicitly provide that the rule will no longer be good law. Graham Virgo in his journal, Patel against Mirza, One Step Forward, Two Steps Back, believes that the application of the impari delicto rule is no longer useful in the UK. Similarly, the status of the locus commutatio rule is unclear, as Lord Thompson made no mention of it in his judgment. According to Professor Burroughs in his journal Illegality after Patel and Mirza, while the majority judgment did not attempt to apply the locus commutatio rule separately, this does not necessarily mean that the rule will no longer be used in courts. This is because there may be circumstances where the claimant can only show unjust enrichment by the other party through invoking the locus commutatio rule. However, Mark Law and Graham Virgo is of the opinion that the rule will no longer be applied by courts in the UK. Hence, it can be said that while these two rules will not operate as a strict or explicit rule on its own, they may still be considered within the limits of the trio of consideration. It should also be noted that the new approach may only be implemented within the law of contract and not illegality in other areas of law. Having considered the current situation in the UK, what then is the current situation on the law of illegality in Malaysia?
It can be observed that the Malaysian courts have somewhat favoured the new framework modelled by the UK Supreme Court in Patel and Mirza. The earliest adoption of this new approach in Malaysia can be seen in Pang Mun Chung and another against Chong Hui Chan. This case concerned the recovery of money by the plaintiffs after they attempted to circumvent a bank policy. The judges found that no illegality was committed and also held in abeyance that even if the agreements were illegal, the plaintiffs would still be entitled to the money based on the trio of considerations laid down in Patel and Mirza. The judges also mentioned that the cases following the reliance principles of Tinsley were no longer good laws. However, the status of this case remains unclear because by virtue of the doctrine of judicial precedent, a court of appeal is bound by the decisions of the Privy Council made prior to 1985. This case made no mention of the existing Privy Council and Federal Court decisions regarding the rule-based approach. Nevertheless, the Malaysian Apex Court subsequently adopted the Patel rule in Liputan Symphony against Pembangunan Orchid Desa Sendirian Berhad. One of the issues in this case was whether one of the sale and purchase agreements of a piece of land was void ab initio due to its non-compliance with the Stamp Act 1949 and the Real Property Gains Tax Act 1976. The court ruled that the sale and purchase agreement in question was not void because the requirement for the acts to be complied with is not a prerequisite for a contract to be valid. The court also agreed with the Patel rule and found that by applying a trio of considerations, it would be absurd to deny the first defendant's title to the land on the basis that the sale and purchase agreement breached both the acts, which merely aimed to raise government revenue. The adoption of the Patel rule in Liputan was followed by the case of Sarwan Singh Kundan Singh against Amina Fauza, whereby the court utilized the trio of considerations and ordered the recovery of 9 million ringgit paid for an illegal investment scheme which did not materialize. In regard to the not impera delicto exception in Malaysia, it is unclear as to whether the rule-based approach pertaining to the recovery of money paid under illegal contracts has been overruled by the decision made in the case of Liputan Symphony. The contradictions between the Patel rule and Section 66 of the Contracts Act 1950 have not been dealt with. The application of Section 66 has been illustrated in Eng Siu San as well as a more recent case of Tan Chi Ho and Sendirian Berhad against code-focused Sendirian Berhad. The former case states that parties who are unaware of the illegality should be allowed to make a claim, while the latter case states that parties who received an advantage under an illegal contract should be compelled to restore it. These cases were not overruled, hence they maintain their status as good laws. Regarding the second exception of the no reliance principle, although the Liputan case did not explicitly mention the Privy Council case of Sarwan Singh, it can be reasonably assumed that the adoption of the Patel rule in the Liputan case would directly overrule the non-reliance exception. Lastly, the role of the locus penitentiae exception also remains uncertain. The case of Liputan only refers to the case facts of Palanyapa Chetia, a Privy Council case, on the locus penitentiae exception, but made no statements about the status of the principle upon adopting the Patel rule. It is still a mystery as to whether or not the said principle will be applied independently of the rule introduced in Patel, or if it will be subjected to it. In short, the law governing the recovery of money paid under illegal contracts will remain unclear until the federal court clarifies this area of the law in a future case.
The new rule set out in Patel against Mirza has brought both concerns as well as relief to the table. We think that there are three main issues to consider when evaluating this new law. Firstly, whether the rule in Patel against Mirza is principally aligned with the purpose of illegality. Quoting Lord Mansfield in the case of Holman against Johnson, the main tenet of the doctrine of illegality is that no court will lend its aid to a man who founds his cause of action upon an illegal or immoral act. The previous approach employed by the court was a fairly rigid approach, where courts were bound by the general rule and its three exceptions. This approach of letting losses lie where they fell often resulted in unjust enrichment, with innocent parties forced to bear the burden of the court's inaction. The new rule in Patel against Mirza combats this issue far better than the old rule ever did, because to a large extent, the new rule doesn't disallow or place caveats on the court's involvement. The court's new willingness and ability to adjudicate contracts tainted with illegality affords people far more protection than the old rule ever did, enabling courts to mitigate the effects of the illegal or immoral act. Hence, the rule in Patel against Mirza does a better job at upholding the dignity of the legal system and condemning illegality. The second issue is whether the new approach ensures more certainty and uniformity than the old approach. In their 2010 report, the Law Commission considered the more flexible approaches to illegality employed in other jurisdictions such as the United States of America, Australia, and New Zealand. They found that the flexible approach did not result in greater uncertainty, but rather that the approach adopted in Tinsley against Milligan resulted in greater uncertainty because it was being applied inconsistently in domestic cases. Now, we concede that having a set of strict rules to apply and abide by would be the most certain way of handling cases in regards to illegality, especially so in lower courts. The sheer volume of cases that appear before these courts make it impossible for every single one of those judges to apply the same range of factors approach or trio of considerations across the board. However, the non-exhaustive list of considerations provided by Lord Tolson in his majority judgment does a good job at giving judges a better idea on how to adjudicate contracts tainted with illegality. Hence, while the issue of arbitrariness is not fully resolved under Patel against Mirza, it is much clearer than the old rules, and the hope here is that the wider, non-formula based approach will give rise to a more just legal system as a whole. The third and final issue is in regards to the role of judges and the limits of their discretionary power. The principles set out in Tinsley against Milligan caused a lot of dissatisfaction, prompting calls for legislative change in regards to the defense of illegality. The Law Commission did consider the defense of illegality in their 2010 report and recommended a statutory reform of the law of trust and unjust enrichment. However, Parliament chose to take no action. Hence, the next best alternative to statutory protection would be common law protection, and the scope of common law protection offered in Patel against Mirza is far broader than the scope of protection offered under the old formula-based approach. Moreover, the issue of an excess of discretionary power granted to judges is rather moot, since Parliament, being the supreme law of the land, can step in at any moment and alter the course of illegality and limit the judge's discretionary power. All in all, while the rule in Patel against Mirza hasn't been utilized enough for us to make an informed evaluation of the rule, we do think that at this point in time, Patel against Mirza is definitely a step forward from the previous rule and is a step in the right direction in regards to the defense of illegality.
The United Kingdom Supreme Court's decision in Patel and Mirza has resulted in a significant change in the UK and Malaysia, but the law in this area has not been settled and clarified. As mentioned, there are underlying issues with this approach, and it might not be feasible to be put into practice effectively in terms of uniformity and certainty. Moreover, there have been no contract law cases since Patel and Mirza to demonstrate application of this case. Hence, while it is a good path, it is too broad and underdeveloped, lacking insufficient case law to act as a guideline. It has, however, been discussed in cases outside of contract law such as tort law, as seen in the case of Henderson and Dorset Healthcare University NHS Foundation Trust. In this case, regarding a claim in negligence, the court held that the decision in Patel and Mirza did not specifically overrule any cases besides Tinsley and Milligan. But for the time being, in regards to the defense of illegality in claims for recovery of benefit conferred under contracts tainted with illegality, this approach allows judges the freedom to consider a whole range of factors in order to make a fair decision.